Hi, I'm James Dickey, Senior Counsel for the Upper Midwest Law Center, Minnesota's nonprofit public interest law firm that fights for liberty and the rule of law. Welcome back to the Minnesota Law Report, where we update you on important developments on legal issues in Minnesota and how we at UMLC are your voice fighting for you in the courts. Ever since the November 2024 election, UMLC has been hard at work addressing pressing Minnesota legal issues in court. Where we see elected officials failing to uphold the law or openly violating it, we take action on behalf of the people. And so that's exactly what we did when we represented our friends at Minnesota Voters Alliance in the Minnesota Supreme Court this past January and held Governor Walz accountable under Minnesota election law related to his illegally called special election for House District 40B. The Minnesota Supreme Court once said, "The foundation upon which an election system rests is the confidence which the electorate places in that system." This is common sense to many of us, but Governor Walz cast the obvious meaning of the law aside and shook that confidence when he tried to call a special election for House District 40B before the law allowed. And Secretary of State Simon failed to stand against Governor Walz's clear abuse of power. After the 2024 election, to recap, Curtis Johnson, the DFL candidate for House District 40B, was declared the winner. But just a few weeks before the election, it had been reported by Alpha News that he didn't even live in the district where he supposedly won. But the Minnesota Constitution requires a representative to live in the district for which he's running at least 6 months immediately before the election. So, after the election, a lawsuit was filed to challenge Johnson's eligibility under the Minnesota Constitution. And on December 20th, 2024, the Ramsey County District Court in St. Paul decided that Johnson hadn't lived at his residence for that 6 months. The court ordered that Johnson was not eligible to serve as representative for House District 40B and that he couldn't take the oath of office. Alpha News' reporting once again proved true when mainstream media didn't show up. A week later, knowing that he had no chance to win on appeal, Johnson released a letter saying he would not appeal the election contest. But he also claimed to resign from office. And there's just one problem with this. He can't resign from an office which he doesn't hold. This is like saying, "You can't fire me, I quit." Under Minnesota law, resignations can only be made by incumbents. Until January 14th, 2025, then, at noon, Representative Jamie Becker-Finn was still the incumbent. Minnesota law says exactly what must happen when a vacancy is created by a successful election contest. Minnesota Statute Section 204D.19, Subdivision 4 allows the appropriate House of the legislature to review the court's decision and decide whether to hold their own trial or accept the judge's decision. Under the separation of powers in the Minnesota Constitution, the legislature manages its own affairs, and the courts have very limited jurisdiction as to who can sit in any House seat. If the House accepts the district court's decision, the governor has to call a special election within 5 days. If the House decides to take up the case and have its own trial, the governor has to wait. But only if the House does nothing can the governor then take action on his own accord 22 days after the first day of the legislative session. And because the House hadn't done anything by December 27th, 2024, and obviously it couldn't have done anything because day one of the session was January 14th, Governor Walz had to wait until February 5th, 2025 to call a special election unless the House acted otherwise after January 14th. But that's not what Governor Walz did. On December 27th, 2024, within minutes of Curtis Johnson's fake resignation. And how did that happen so quick exactly? Governor Walz called for a special election to take place on January 28th, 2025, a whole 40 days before law allowed. Governor Walz also required all candidates to file their affidavits of candidacy by December 31st, 2024, which gave only 4 days to file in violation of another statute, which requires that at least 5 days special notice has to be given for special elections. Despite these errors, obvious errors, the Secretary of State dutifully proceeded forward and improperly certified 2 candidates for the special election. So, we sued the governor and the Secretary of State. We argued that the governor's writ of election was illegal, and the Minnesota Supreme Court needed to step in and shut it down. On January 17th, 2025, in a big win for Minnesotans and the rule of law, the Minnesota Supreme Court unanimously agreed and said that the governor's special election was called prematurely. The court required the Secretary of State and Ramsey County to take all steps necessary to cancel the special election set for January 28th, and said all absentee ballots already counted could not be counted in that special election. But the story doesn't end there. With the loss of Johnson, the House went from being split evenly among party lines at 67-67 to 67-66 in favor of the Republicans. In an attempt to deny Republicans the ability to use their majority, all Democrats boycotted the first day of the legislative session. Secretary of State Simon, again, presiding over the House chamber until a speaker was chosen, claimed that since there were only 67 members present and not 68, a quorum was not met. And a quorum is the minimum number of members required to conduct business. Simon unilaterally attempted to adjourn the House, which he has no power to do. Minnesota Republicans ignored it, went along with their constitutional duties anyway, and under Minnesota statute, a new presiding officer was designated, a quorum was called, with 67 out of 133 members, seems like a majority to me, present, and the House went about its duties of electing officers and running business. Secretary Simon then decided to sue Republican leadership, arguing that the House did not have a quorum, that the election of a House Speaker was invalid, and any other actions based on the election are invalid. Apparently, he wanted to hold the gavel and filibuster despite having no lawful control over the Minnesota House. We filed a friend of the court brief, known as an amicus brief, along with Professor Elon Werman of the University of Minnesota Law School, which shows that a quorum under the Minnesota Constitution meant a majority of duly elected and chosen members, which is 67 out of 133. Unfortunately, the Minnesota Supreme Court incorrectly agreed with Secretary Simon, and on January 24th, 2025, stated that a quorum under the Constitution is a majority of authorized seats of the House, regardless of how many are empty. Thus, under the Supreme Court's incorrect determination, 68 members are needed in the House to have a quorum. But even that was not enough for Secretary Simon. He went even further beyond his constitutional power and stated that, absent a quorum, all the House could do is adjourn. Yet under the Minnesota Constitution, a smaller number of members of the House can compel the attendance of absent members under penalties it may provide. Simon pressed his luck further, continuing to convene the House, claim that there was no quorum, and adjourn the House unilaterally without a motion from the floor. Democrats continue to fail to show up for work to perform their duties as duly elected representatives. Republicans then attempted to use their constitutional power to compel absent members to appear under threat of penalties, but Simon unlawfully ignored them. So after 4 days of attempting to bring a motion to compel, the House Republicans had no choice but to ask the Supreme Court to intervene again. On January 30th, the GOP filed a suit against Secretary Simon, accusing him of refusing to allow them to compel absent members of the House to attend under the Minnesota Constitution. The GOP members were right. The Minnesota Constitution not only sets quorum at a majority of duly elected and chosen members, which, in my opinion, continues to be 67 out of 133, but it also allows the smaller number to compel absent members. Perhaps unfortunately, though, before the Supreme Court had a chance to decide on the issue, which I think very well would have gone in favor of the Republican representatives who filed the suit, the House came to a power-sharing agreement. The deal was announced on February 5th, 2025, just hours after Governor Walz finally properly exercised his power to call a special election for House District 40B for March 11th of this year. Under the agreement, the DFL caved, and the Republicans finally gained the Speaker of the House position, but agreed to share power if a DFL representative wins House District 40B, which is not a sure thing. But the story continues even further. The Republican Party of Minnesota has now filed petitions for recall against, as far as I'm aware at this point, 29 DFL House members for boycotting the legislative session and taking tax dollars despite not showing up for work. What a gig. Those petitions will go to the Minnesota Supreme Court to determine if those grounds for recall are valid. Under the Minnesota Constitution, Article 8, Section 6, the standard to meet for recall is serious malfeasance or nonfeasance. And while the Supreme Court has rarely had to decide this, Minnesota statute has defined both. Section 211C.01 defines malfeasance as the intentional commission of an unlawful or wrongful act by a state officer other than a judge in the performance of the officer's duties that is substantially outside the scope of the authority of the officer and that substantially infringes on the rights of any person or entity. It defines nonfeasance as the intentional, repeated failure of a state officer, other than a judge, to perform specific acts that are required duties of the officer. And it sure seems to us like not showing up for work for 3 weeks and change is an intentional, repeated failure to act as a legislator. Taking tax dollars for not working as well is likewise highly offensive to most. But whether the refusal to do constitutional duties by the boycotting DFLers meets this requirement is a legal question that the Supreme Court will decide soon. So while the House is back and running at full force, the saga continues on with the recall petitions now to be decided. But regardless of the result of these petitions, it seems to us a good thing that the Supreme Court will get to the opportunity to clarify what the legal standard is, and as a result, what they decide will apply to both sides going forward. Well, that's it for this episode of Minnesota Law Report. You can learn more about the Upper Midwest Law Center by visiting umlc.org, and you can also make a confidential, tax-deductible donation on our website. As always, we urge you to do that. We are fully donor-supported and charge our clients nothing. We are standing up for you in court, like we did against Governor Walz, like we did against Secretary Simon. And we want to fight for you on every front. Help us do more for you by making a donation today. Thank you, and we'll see you next time.